Yes, yes.
So, Malad, the first one would
You
be
have to that A you have finished.
no, my lord. I have not finished. I have finished part of A. Combination or outcome of interlocutory orders. I have not yet dealt with the issue that this is a case of perception subjectivity driven inquisitorial process. Now, my lord, having regard to this, my lord, the first authority, first, my lord, this has to be read with the second question. My lord, I will answer both. That whether a writ court, while exercising power of judicial review, my lord, this is not a PIL, while is exercising power of judicial review, could have invoked 165. And this is not classical cross-examination that the writ court can do, allow. But this is where the court steps into the arena and starts examining, my lord, the parties to the proceedings on its own to clear up doubts. So, my lord, first judgment I am going to cite on this issue would be Krishnalal Chawla. This is page 344. This is volume 2. Well, I have given 3 compilations. Volume 2, if your lordship kindly takes. Oh, volume 2. Thou? Arekta ache? There are no. I am giving up. I am giving. I am handing up. Dichi. Dana. Otana. Sorry. This is volume 2. This is going to be a pile of papers at the end of hearing. Well, so many trees are being burnt, used for no reason. Malad, kindly take this compilation. Kindly take page 344. Kindly take, my lord, for once, paragraph 20, na? Kindly take paragraph 20 of this judgment. Murders got paragraph 20. Citation is, my lord, 2021.
Yes, got it.
5
Yes,
SCC. My lord, kindly take paragraph 20. It is said that every trial is a voyage of discovery in which the truth is the quest. In India, typically, the judge is not actively involved in fact finding owing to the adversarial nature of our justice system. However, section 165 of the Evidence Act, by providing the judge with the power to order production of material and put forth questions of any form at any time, marks the influence of inquisitorial process in our legal system. Murders got that?
Yes.
So, this wide-ranging power further demonstrates the central role played by the magistrate in the quest for justice and the truth in criminal proceedings and must be judicially employed to stem the flow of frivolous litigation. So, my lord, this is where inquisitorial process is embedded in our judicial system. Now, my lord, whether in a judicial review proceedings under Article 226, this kind of inquisitorial process could be undertaken or not, I am referring to Meerut Development Authority. This is volume 1.
That has been cited earlier.
I don't think so, because I don't think Meerut Development Authority has been cited.
Yes, Mr. Dotto cited.
2009 6 SCC Meerut Development has been cited. I don't think.
I may slip my, but I thought it was.
So many judgments.
To give us the page.
This is page 89, volume 1. There are 3. 2009 6 SCC 171. I don't think, my lord, learned advocate general has cited this. But I will stand corrected, my lord. I don't think, my lord.
Which one is that?
Volume 1.
Volume 2.
There are 3 volumes, my lord. I have given only 3 volumes.
Arikta volume put eta.
Amar mone hai na eta side.
Is this the 3rd volume?
This is the 3rd volume where we the orders, different orders passed by. Yes, that is
You are
the
referring to volume 3, which is
volume
that?
2, volume 1.
You have said that you are giving 4 volumes.
No, 3 volumes. 3 volumes.
This is volume 3 then.
Absolutely, my lord. My lord, we will mark it as volume 3 if necessary, my lord. My junior will do that at the end of hearing today. Volume 2, my lords have got that. Volume 1, my lord has got that. Kindly take page 89 and take, my lord, paragraph 67. পড়োনি তো এত জাজমেন্ট সাইট হয়ে গেছে না But this is a case where, my lord, tender was cancelled and it was decided to change the nature and character of the land, use of the land. That was challenged. And, my lord, kindly take paragraph 67 summarizes what is the scope of the litigation. Kindly take paragraph 68, 67 and 68. I will not read 67. I will read 68 and 69. Because my case before Lordship is that inquisitorial process cannot be undertaken at all in writ proceedings, in judicial review proceedings. My lord has got 89. May I read out, my lord, Mr. Justice Mitro? The impugned judgment illustrates the danger of judges wrongly, though unconsciously, substituting their own views for the views of the decision maker, who alone is charged and authorized by law to exercise discretion. With respect, we find that the High Court virtually converted the judicial review proceedings into an inquisitorial one. The way proceedings went on before the High Court suggests that as if the High Court was virtually making an inquiry into the conduct and affairs of MDA, in a case where court was merely concerned with the decision-making process of NDA in not accepting the offer or tender of AMS in respect of disputed plot on the ground that the offer made was less than the reserve price fixed by MDA. We express our reservation in the manner in which High Court dealt with the matter. The High Court went to the extent of holding that there was a concluded contract between MDA and MS. Of course, learned senior counsel so-and-so did not support the findings. So, my lord, this inquisitorial process, and since 165 is an integral part of the inquisitorial process, this could not have been done. Where it could have been done, my lord will kindly take Manohar Joshi. This is, my lord, volume 2, page 61258, and it is 2012 3 SCC 619. Kindly take paragraph 185.
Page, volume 2 page.
Volume 2, page 258. I will trouble your lordship only with one paragraph. Paragraph 185.
258 বলুন
258. এটা volume 1 না volume 2 রে? Volume 2 তো. 258 is the running page, my lord. The paper book page. And, my lord, I take your lordship to 328. That is the running page. Now, my lord, kindly take page 18, paragraph 185. My lord has got that, my lord. Public interest litigation is not in the nature of adversarial litigation. My lord has
paragraph
185. Public interest litigation is not in the nature of adversarial litigation, but it is a challenge and an opportunity to government and officers to make basic human rights meaningful as observed by so-and-so in Bandhua Mukti Mecha. By its very nature, PIL is inquisitorial in character. Well, ironically, this writ petition contains a paragraph that this is in the nature of PIL. Had it been a PIL, again, my lord, I have my own reservations. This kind of inquisitorial process could have been taken, but that is also subject matter of dispute. But whether in a judicial review proceedings, this kind of inquisitorial process, my lord, there is no doubt about it that 165 is an inquisitorial provision, could have been undertaken. The answer would be, in my respectful submission, in the negative.
yes.
My lord, I have tried to summarize what was held by Lord Denning in Jones versus that's the kind of the pointer. May I just give the summary? Your Lordship will find this Jones judgment at in volume 1, page 53 to 63. And I will not trouble your Lordship with the judgment at all because this has been cited by Mr. Mitro, Mr. Joyanta Mitro, as well as by Mr. Aninda Mitro. But my summary would be like this. Court cannot investigate on behalf of the society. This is the first finding or the first limitation imposed in Jones. Court cannot call witness whom he thinks might throw some light on the facts. 53 to 63, my lord. Court cannot call witness whom he thinks might throw some light on the facts. Pausing here for a moment, the order dated 6th of February 2023, the Honorable Single Judge says in its order, in the order, that I think I have to get some facts from the 5 districts, from the interviewers of 5 districts. So this is against this principle. Court should be content with the witness called by the parties. That did not happen in this case. Court may ask questions to clear up any point that he has been overlooked, and court cannot assume the role of an advocate. So, my lord, all the parameters or all the, my lord, this is the plinth and amplitude of the power to be exercised under 165. And in my most respectful submission, we due respect to the Honorable Single Judge, my lord, this has not been done. This has been violated. And these forms, my lord, what should I say, the foundation of this judgment.
Yes.
And the conclusion that there was scam, etc., is also, my lord, a conclusion which was driven at on the basis of this inquisitorial process.
Yes.
So, my lord, my second, my lord, these are the 3 judgments I cited right now. My lord, Jones has already been also been followed even in the recent. I'm not citing the judgment, but that is in the compilation. Lordship may kindly take note of Muhammad Abdul Wahid versus Nilofer, 2024 2 SCC 144 at para 3. Mala, I'm not going to read that. 2024 2 SCC para 144 at page 144 at paragraph 3.
Yes.
Then, my lord, I take your lordship, my lord, whether this kind of fact-finding exercise could have been carried out or undertaken by the Honorable Single Judge. My lord will. But I will also answer the scope of aptitude test later on. Now, in this fact-finding exercise, what was the nature of fact-finding exercise? This is very important. My lord, 3 basic questions were put to the candidates. What were the nature of questions? What were the questions? May I take your lordship? I have just tried to summarize the questions which were put. What, according to you, is aptitude test?
If 165 domain is restricted by your argument, question of
no, my lord, my question is that my next argument would be that by judicial interpretative process, if we take the judicial interpretative process to that extent, when a particular expression has been defined in an act, in a regulation, that has been defined, my lord, aptitude test, my lord, through this process, no words, no concept or no words could be added or subtracted in those processes. What has been done, as if the blackboard has not been used, if the classroom demonstration has not been given or taken, then there was no aptitude test at all. That is the conclusion arrived at by the Honorable Single Judge, and that is evident from all the depositions. When we have read all the depositions, 3 questions are very pivotal. What, according to you, is the aptitude test? Well, kindly take it from me. Your lordship can take note of, because was there any blackboard? Were you asked to do anything on the blackboard or using any model in the blackboard to explain anything?
Yes.
As if only and only when blackboard is used, and if only when a candidate is proficient in using the blackboard, he would be eligible for the post of primary teacher. Now, my lord, now having regard to this, my lord, kindly take the definition of aptitude test, which your lordship has read.
Been
But
taken to that.
But my lord, the aptitude definition of aptitude test
Yes.
is clear, is unambiguous.
That is your argument that you cannot add something to the definition.
Yes, my lord,
which
that is what I
already
am on. So, my lord, my question is that my submission would.
goes back to be an this
Yes, yes.
this investigation.
My lord,
which was done by
why I'm making this submission? Because for the reason that I am taking this submission as my alternative submission. Suppose your lordships are not with me in the first point, then I have to demonstrate before lordship.
We shall ask you, Mr. Mujumdar.
My lord,
If
my
the
lord,
counter
my lord,
argument
this is
comes, we will ask you.
this is ex abundanti cautela. So I have to do that, my lord. Kindly allow me to do that.
We cannot just stop asking questions.
No,
to
no,
the
you can. Definitely your lordship can ask,
So
obviously.
that you
My
will
lord, I
answer.
invite your lordship to ask as many questions your lordship
Exactly.
wants.
So we want to hear what is their stand.
My lord, your lordship will
Your
definitely hear the
your
stand.
basic argument we accept. Application of 164, how you will do it in one sort of a
Yes,
litigation.
yes,
we have
yes.
seen.
My lord, only for the sake of completeness, only for the sake of completeness. My lord, kindly take two judgments. That is one thing interesting, my lord. My lord, this concept of classroom demonstration was for the first time introduced in National Education Policy 2020. My lord, we have included the relevant part of the National Education Policy 2020 in our compilation, which your lordship will find at page 377, which is volume 2. Kindly take that one. Whether 5.4 na? Recruitment and 377, volume 2.
Last
Kindly
page.
take.
Yes.
Teachers' eligibility test will be strengthened to inculcate better test material, both in terms of content and pedagogy. The tests will be also extended to cover teachers across all stages, so and so, so and so.
Which paragraph you are reading?
Paragraph 5.4 of the NEP, National Education Plan 2020.
Yes.
For subject teachers, suitable TET or NTA test scores in the corresponding subjects will also be taken into account for recruitment. To gauge passion and motivation for teaching, a classroom demonstration or interview will become an integral part of teacher hiring at schools and school complexes. So, my lord, even in NEP 2020, classroom demonstration was not made mandatory. Even, my lord, some kind of interaction with the candidates is treated to be sufficient. And the honorable single judge, in all the depositions your lordship will find that the first question is that, or the main questions are that, was there any blackboard? Did you use blackboard? Did you where there was
No,
where you
the national education policy includes class demonstration and
or
interview.
kindly take or, my lord, or interview. And this was introduced only in 2020. And
Yes.
this recruitment process was undertaken in 2016. Interview, I mean, the appointment letters were issued in March or February 2017. So, my lord, this is what it stands. And, my lord, these particular words, this through judicial interpretative process, this cannot be done. Kindly take, my lord, these two judgments. My lord, first one is in my compilation, that is Kotak Mahindra Bank 2022 9 SCC 186. This is at page 8 of volume 1, right? Volume 1. And your lordship will kindly take only paragraph 76 and 77. '76, my lord Muhammad Shahabuddin was referred to. 76 and 77 is the summary. It is more than well settled that when language of a statutory provision is plain and unambiguous, it is not permissible for the court to add or subtract words to a statute or read something into it which is not there. And my lord, in my most respectful submission before lordship, but this is what has been done. Because if there is no blackboard, no aptitude test was held.
Yes.
My lord, this was, my lord, the pointer. Now, my lord, next one, your lordship will kindly take. Next, in this line, I'm just giving the citation and the paragraph. No need to read. My lord, it is the judge's case, Deokinandan Agarwal, 1992 supplementary SCC 1 323, which your lordship will find at page 41 of volume 1. 1992 supplementary 1 SCC 323 at para 14 volume 1.
Yes.
Then, my lord, the next one, the next proposition which I want to canvass. So, my lord, I've dealt with 165, I've dealt with interlocutory order. I've also dealt with, my lord, whether the evidence taken by the court could be the basis of this kind of order of cancellation of appointment of 32,000 untrained candidates. But I have demonstrated from the table and also from the deposition what was the nature of questions being asked. And also, my lord, there is a complete mismatch between the candidates who were examined and the interviewers who were examined, that this evidence is not, I should not use the word sufficient, it is not, it is not at all evidence for the purpose of quashing the appointments of 32,000. The judgment, though, my lord, a process of taking evidence was undertaken by the court, but, my lord, the judgment is based on no evidence. My lord, kindly take for once. This is Om Prakash Chautala. Sorry, my lord, kindly take first. I'm sorry, kindly take for once. This is AIR 1993, page 169. Your lordship may kindly take. This is a full bench of Calcutta High Court. AIR 1993, Calcutta, 144. The relevant paragraph starts from paragraph 100 onwards, but I will take your lordship directly to para 112 and 115. Oi, Ratan Lal. My respectful submission before your lordship that there has been, kindly take 115. Kindly take act. This is a judgment for the proposition that there has been complete failure for, my lord, perverse treatment of evidence.
Which para you are showing?
I am showing from, I am giving your lordship the paragraphs 91, 93, 101, 102, 104, 107. Then, my lord, 108, 109, 110, 112. 112 is relevant, my lord. I will only read relevant paragraph. Kindly take page 112, which is at page 206 of the compilation.
Yes.
The perversity of approach vitiated by reliance on irrelevant materials. Page 1, paragraph 112, my lord.
112.
Page 206.
You're reading from the middle.
No, my lord, yes, I'm reading from the mid. Man, I'm not troubling your lordship with the entire.
Where you are there?
My lord,
Which
the,
line you said?
my lord, the
Perversity of
perversity of the approach. The perversity of the approach being vitiated by reliance on irrelevant materials or exclusion of relevant material in reaching the inference or inference on no evidence is a substantial question of law.
Yes.
The next one in this line would be, my next submission would be,
Yes.
allegations of malafide are serious in nature and they essentially raise a question of fact. It is therefore necessary for the person making such allegations to supply full particulars in the petition. If sufficient averments and requisite materials are not on record, the court would not make a fishing and or roving inquiry.
Yes.
Mere assertion, vague averment, or bold statement is not enough to hold the action to be malafide. It must be demonstrated by facts. Moreover, the burden of proving malafide is on the person leveling such allegations, and the burden is very heavy. Then they refer to Royappa. This judgment has been followed in a service matter, that is Chandra Prakash Singh versus Chairman Purbanchal Gramin Bank. It is 2008-12 SCC 292 at paragraph 30 and 34. This is at page 155 of the compilation. 12 SCC 292 at para 30 and 34. Kindly take 30. This was a matter relating to promotion. Kindly take page 30.
Yes.
All that has been alleged in paragraph 11 and 14 of the writ petition by the appellants reads as under: that the written test was held on such and such date, which was conducted by the opposite party 10, who was the officiating chairman of the bank at that time, that it was specifically mentioned in the above mentioned complaints that opposite party number 10 was making grounds for promoting his real brother and his cousin, namely Syed so and so, who are already employed in the bank as clerk cum cashier, and he wanted their promotion to officer scale 1. The above extracted allegations are absolutely vague, indefinite, and did not contain sufficient material as required under the law in support thereof. The appellants have not established on record that the respondent number 10 so and so, the then chairman, was an instrument in getting his brother and cousin through in the written examination, and later on it was under his influence that the selection committee has selected his two relatives in the post in question. Para 34. After dealing with several judgments, including, my lord, this judgment which I have referred to, kindly take. Thus, as a proposition of law, the burden of proving mala fide is very heavy on the person who alleges it. Mere allegation is not enough. Party making such allegations is under the legal obligation to place specific materials before the court to substantiate the allegation. There has to be very strong and convincing evidence to establish that allegations of mala fide specifically and definitely alleged in the petition, as the same cannot merely be presumed. The presumption under the law is in favor of the bona fides of the order unless contradicted by acceptable material. But in this case, there is no allegation against, my lord, these 32,000 candidates specifically. We have filed our appeal. There is no counter to the effect that these I am representing about 1,600 candidates, that these 1,600 candidates were directly involved in, my lord, this kind of job rigging.
Yes.
Now, my lord, now what we have done, Mr. Chatterjee has given filed an affidavit, where, my lord, we will find the number of the last empanel candidate with respect to a particular category, and, my lord, the petitioner's position with all the breakups. What we have done, what my learned junior has done, unbelievable task he has done. Kindly take this chart. We will circulate it. This is based on their affidavit.
Whose affidavit?
My lord, 2 copies.
Whose affidavit?
My lord, Mr. Chatterjee's affidavit to the stay application filed by the board. Affidavit in opposition.
Mr. Chatterjee.
Mr. Chatterjee's affidavit in opposition to the stay application filed by the board in one of the read petitions, with one of the read petitioners. Well, I promised your lordship that I will hand out colorful charts. Well, at least that much I have lived up to. Rest I don't know. Well, kindly take one by one. Konta dekhao bol. Well, kindly take LEC. Well, I'm sorry, my lord, your lordships have got that. LEC is the last empanel candidate.
Yes.
Then, my lord, your lordship, that is, my lord, that is printed in red. Circulate LEC is the last empanel candidate. Now, my lord, kindly take. This is with respect to this last empanel candidate. The petitioner who would be under consideration would be petition number 37. Kindly take the marks.
No, what argument you are advancing?
Well, I am advancing the argument that the score obtained in this aptitude test did not have a telling impact as alleged or at all. Even some candidates who are petitioners before lordship scored quite highly in the aptitude test, as would be evident from this chart. And I will demonstrate one by one. Kindly take from LEC. Well, I will not read everything. LEC 37 was secured by LEC, last empanel candidate. We have added up. We added up the TET score, Madhyamik score, HS score, and TET plus MP plus HS is equal to 14.107. In the case of last empanel